Candidates Forum for the 15th Judicial District Attorney's Office, sponsored by the Lafayette Bar Association and Foundation. My name is Professor Bill Davey. I have the honor of teaching communication law and ethics at the University of Louisiana. And I think it is fitting today that we turn our attention to the judicial branch of government. One of our Supreme Court Justices, Ruth Bader Ginsburg, is lying in state in the U.S. Capitol as we speak, the first woman in our nation's history be accorded this honor. But we're honored here today to have lawyers who are taking CLE credits and also listening to two candidates for the District Attorney's Office. First, we will be hearing from Don Landry, who holds degrees from the Southern University Law School and the University of Southwestern Louisiana. He is a partner in the general practice firm of Perrin, Landry and Delaunay. He serves as city attorney in Broussard and has served as town attorney in Erath and has been president of the Alumni Association of Louisiana Lafayette. Our format will allow him to speak for 15 minutes on important elements of criminal procedure for the CLE credits. He will be followed by Daniel Landry III, a lifelong resident of Lafayette, who serves as an assistant district attorney for the 15th Judicial District Court. He is a principal attorney for the Landry Law Firm, graduated from the LSU Law School and holds his undergraduate degree from LSU as well. He will follow Don Landry, and afterward we'll have time for questions and answers, including questions from the lawyers assembled here at the Lafayette Bar Association and those who are watching in their office at home remotely online. So without any further ado, let's begin today's meeting with Don Landry.
Good afternoon, and thank you so much to the Bar Association, for Ms. Claire, our staff. Honored to be here, happy to be here. The Bar Association office is really a prize, and I'm sure happy that many, many years ago we all participated in raising the necessary monies to get this beautiful building polished up for all of our attorneys. I am Don Landry. I practiced law here in Lafayette Parish for many, many years. I was with the District Attorney's Office for 34 years, 24 of those 34 years as a felony assistant district attorney. I was given an option as to what I might speak on this afternoon, and I picked bond reductions in bonds and bail. So please bear with me as I cover that very interesting subject with you. Imagine this, 12:57 in the evening, your phone rings. It's 7 minutes after midnight. It's probably not going to be very good news, not going to be a good call. And one of your great clients calls you and says that his son has been arrested, is in jail now with a serious felony offense. And his objective is get him out of jail. So what do you do at that point in time? He's a good client. You know the family. Do you call the commissioner? Do you call the judge at 12:57 in the morning? It happened to me when I first started practicing law. I might have made the wrong decision. I made the call. So I'll leave it up to you as to whether or not you think you ought to call the judge or commissioner at that time of night. Seriously, we're here today to talk about bonds and bail. I'm going to tell you that it's a very important function. It's a very important part of our judicial system. Somebody is in jail and somebody wants to get out of jail. We have to make some decisions from the district attorney's desk. And you, as a defense attorney, if we have any defense attorneys with us, also have to make some decisions. You could really score some big points with your client if this was one of those crimes that you could maybe get released on your own recognizance, an ROR bond, as they say. But this particular offense probably wouldn't qualify. But under our Louisiana Code of Criminal Procedure, an ROR bond will not be available and is prohibited if your client has committed any of the following. And I'll list you some of those offenses. Remember, it won't apply to the example I just gave you. Crimes of violence, felony offense involving the discharge of a firearm, a sex offense where the victim is under age 13, vehicular homicide, domestic violence battery, and domestic abuse aggravated assault, cyber stalking on the third conviction, false imprisonment with or without a dangerous weapon, killing a child during the delivery, cruelty to persons with infirmities, DUI second offense, aggravated cruelty to animals, injury or killing a public police animal, jumping bail or jumping bail even on an outside warrant, meaning from out of state, and violation of protective orders. Possession, manufacturing, possession with intent to distribute controlled substances. There's also a presumption that if you are not on bail, if you are on bail and are arrested on a new felony offense or failing to appear on the underlying felony, you will not qualify for the ROR. So before coming today, I called and talked to some of the bondsmen just to get a different perspective on what's going on now. We all know how difficult it is in this time of COVID-19, hurricanes, and so forth. And so the bondsmen, they're complaining a little bit because there aren't a lot of people who are charged with the misdemeanor type offenses or out on some of these warrants that are actually being bonded out. They're not setting bonds on those offenses. They go, they sign something, they promise to appear, and that's the end of the story for now. The bondsmen don't like it. Understandable. They don't get to make money on those types of bonds. But the more serious felony charges are being dealt with. Those defendants are being arrested, the murders, the attempted murders, the armed robberies, and those types of charges. Once we get through this pandemic, I think maybe we can go back to what people had called the normal. Maybe we'll go back to normal and we'll be dealing with all of the offenses in much the same way. Since I only have 15 minutes, I'll cover a few other things for you that are in the statutes as they relate to bonds and bond reductions. I will tell you that the factors to be considered in fixing a bond, since you're not going to get an ROR in that example that I gave you. So we look at Article 316, and the amount of bail shall be fixed in an amount that will ensure the presence of the defendant as required and the safety of any other person and the community having regard to, and here are the things you should consider. The seriousness of the offense charged, including but not limited to whether the offense is a crime of violence or involves a controlled dangerous substance. The weight of the evidence against the defendant, the previous criminal record of the defendant. And if you do your homework, you can get that rap sheet, but I caution you a little bit. We all know, if we've been to the courthouse, we check these rap sheets and we want to prepare as well as we can for our clients and really up to date. It's lacking entries on the actual rap sheet, or perhaps there's something on there that shouldn't be on there. So I just caution you to check them out real well. We also consider the ability of the defendant to give bail, the nature and seriousness of the danger to other persons or the community that would be posed by the defendant's release. The defendant's voluntary participation in a pretrial drug testing program. Some of you probably have experienced this. You go to court for a bond reduction. The judge suspects, you suspect, the defense attorney volunteers and says, I think my client has a drug problem, brought to the judge's attention. The judge might make that a condition of the release. In addition to whatever monetary amount he might set, he may make it a condition that he be tested for drugs and receive whatever treatment might be recommended. I think it's a good thing. And I think most people would think that it's a good thing. Try to end that problem, or at least get some help for it. Whether the defendant is currently out on a bail undertaken on a previous felony arrest for which he is awaiting institution of prosecution, arraignment, trial, or sentencing. any other circumstances affecting the probability of defendant's appearance, and of course, the type or form of bond. There's different ways to post bond. We talked about the ROR, there's the cash bonds, called the bonding company. You can put up property bond. There's ways to get people out of jail. And what we're trying to accomplish, folks, is we want to make sure they appear in court. We want to make sure they come to every critical stage of the prosecution, in fact, every stage of the prosecution. That's our aim when we try to get people bonded out of jail. But it's a serious thing. You know, I only have 15 minutes to talk about it, but I would encourage prosecutors and defense attorneys to take it very seriously, because every day in jail for the defendant is one day away from his kids, his family. Every day in jail for the defendant is one day away from work. Maybe he loses his job. Maybe he loses custody of a child. On the other hand, the prosecutor has to make sure that he does everything that he can or she can to get a good bond to guarantee that appearance in court and to protect the community and the victims. That has to be done. You have to work with these people. You have to communicate with them. From the prosecutor's standpoint, and this is how I used to do it, you stay in touch with those victims and their families. They don't understand the process. They just don't understand that there's a bond reduction hearing. You go to the hearing, and they thought it was just a wonderful thing that there was a $100,000 bond, and all of a sudden the bond is down to $15,000. They just don't understand. If you prepare them for it, if you explain to them what the purpose of the bond might be and what the circumstances might be as they come to court and listen to this, they will appreciate it. One thing you don't want to do is give them 3 days notice. I was at a function in Vermilion Parish, and some victim's family member was complaining about the fact that she had gotten a letter and it only gave her 3 days and she didn't know what to do. Well, if you prepare that witness, she'll know what to do and she'll better understand what she needs to do. So I take it seriously, and I think everyone should, because it's important to both sides. It's important to the prosecution, it's important to the defendants. And I think that if we do a good job with all of that, we'll help this system run a lot more smoothly. And that's my goal in presenting to you this information. I hope that you will take a look at all of the statutes. As I said, I only had 15 minutes to give you what I can, but it's some pretty interesting stuff there, believe it or not. And if you look at some of the cases, you'll see that it's very important that we get it right at this stage of the prosecution. So we've gotten through an arrest, we've gotten through a bond hearing, and now understand that we'll be followed by Mr. Landry, and he'll talk about the next step in the prosecution. Thank you very much.
This individual has been arrested. Now, I put this little PowerPoint presentation. We'll try to get through it in 15 minutes. As Donald indicated, it's not a lot of time to cover the criminal justice system. But my name is Daniel Landry, Danny. I'm a lifelong resident of Lafayette and Acadia. Lafayette High School graduate, LSU graduate of political science, LSU Law School. I've spent 12 years as a felony prosecutor with DA Nathan Stansberry, 19 years as a felony prosecutor with DA Mike Carson, the last 6 years with Keith Stutz as the first assistant, and I'm also a director of pretrial intervention services. So I have a total of 36 years of public service in criminal justice. Just a little background information. The 15th Judicial District, which we cover, is the 4th largest by population of the 42 judicial districts and the largest of the 3 parish single districts. Our parish is Acadia, Lafayette, and Vermilion Parish. In 2018, the 15th had the 2nd highest criminal filings in the state with over 9,000. In 2018, we had the 3rd highest in juvenile filings, 2,665, and that has jumped because you now have 17-year-olds in the juvenile prosecution. We serve a population of 341,000, and we serve 26 police agencies in 3 parishes. The current organizational structure of the DA's office, you have the elected district attorney, the first assistant, our 3 parishes. In each parish, we have an executive assistant that oversees the assistants, the felony prosecutors in that area. We have criminal non-sport, juvenile traffic, misdemeanor. I kind of just went through that. There's various components of the DA's office: administrative, felony, misdemeanor, traffic. We have 2 assigned detectives in Lafayette, pretrial intervention, screenings, juvenile division. So the authority of the district attorney comes from the Constitution. And the most important thing here is that the district attorney determines who, when, and how to charge a state criminal law violation. After that individual is arrested and is sitting in jail, ultimately the report will come to us to review. Our obligation is to seek justice rather than merely to convict an individual. The reports come in, there's a data entry, case management. The individual that Donald got the call in the middle of the night, his report will come in. It will be brought to the assistants to review. We try to review the reports within 30 days of receipt. There's several things that can happen. The charges can be accepted, can see if they qualify for pretrial, submitted to a grand jury. So the pre-charging issues we addressed earlier: the setting of the bond, 72-hour hearings, the appointment of legal counsel if they can't afford one, the bond hearings, win-law hearings, pretrial release options, and motions to set bond. After that, a decision has to be made by the assistant DA. Has a crime occurred? What crime? Was all the constitutional protections afforded the accused individual? Can the guilt of the accused be proven beyond a reasonable doubt? If the answer is no, the charges are refused or not accepted. There may be further law enforcement investigation. We also have time limitations to prosecute these individuals. So basically, the assistant determines the appropriate plea offer based upon the nature of the crime, the defendant's past criminal history, strength and weaknesses of the case, victim input, and suitability for pretrial diversion. The process: you have the arraignment where the defendant can plead guilty, not guilty, or not guilty by reason of insanity. There's pretrial motions. There's continued plea negotiations that go on. At this point, we provide this information to the defense attorneys. We have an affirmative duty to be sure that what's called Brady materials, any evidence that would tend to show the innocence of the individual, must be provided to the defense attorneys. Judge and jury trial decision has to be made. There's new law requires unanimous jury verdicts in Louisiana. There was only 2 states, Louisiana and Oregon. In the Ramos decision, which recently was handed down, Louisiana is now a unanimous jury state. Can be found guilty of lesser offense. Post-charging motions. Once they're charged, our office has a general practice of what's called open file policy. We provide the entire police report that we receive to the defense attorneys. They don't have to file any particular motions. We usually just give them the file so that they can do it. In some occasions, they will file Brady motions if they're looking for particular things, or they want a bill of particulars as to when the crime occurred because the police report is a little vague. They can file a motion to quash if there's sufficient grounds. They can file a motion for double jeopardy if the individual may have been convicted in another jurisdiction of the same crime. If the time delays have run, they can file a motion to dismiss the prosecution. They have the right to speedy trial, which has become an issue due to COVID. They can sever the cases if you've got multiple defendants. They can change the venue, which is very common in very high-profile cases. We have some motions to change venue in the Corporal Middlebrook murder case that is coming up next month. And then there can be motions to suppress evidence, which you normally see in the drug track, because if they suppress the evidence, there can't be a conviction. Trial decision, whether it's a jury or a judge, defense attorneys can file a motion to continue. It's very rarely filed by the state, but that's discretion with the court. We are having issues with the voir dire, the selection of the jury. The question is, a lot of these people don't want to come into the courthouse to sit, and they're taking every precaution that we can, but that has delayed the selection of juries and the moving of cases. The Ramos decision came down recently. We're still trying to decide, or the Supreme Court is trying to decide whether or not it applies to old cases. I tried a murder case about 9 years ago, and the verdict was 11-1. I don't know if I'm going to end up having to retry that case. Multiple things that can happen: guilty as charged, not guilty, guilty of lesser offense. I mentioned mistrial because now that we have a unanimous jury system, you're going to start seeing more mistrials, because if you don't get all 12 to agree, case is mistrial. So, and I see a question, but we'll have a question and answer shortly. Defendant gets convicted. When convictions occur, the district attorney's office represents the state in all criminal appeals, all the way up the state side, from the Court of Appeals to the Louisiana Supreme Court. When it falls over into the federal system, you go all the way through the process, all the way up to the United States Supreme Court. I got admitted to practice before the United States Supreme Court in the Dalton Prejean, which was a capital murder case. We handle all of that. Bonds, post-conviction, a lot of people don't realize, but if somebody's convicted, they are entitled to a bond after hearing if the sentence is less than 5 years. If it's more than 5 years, it's the judge's discretion. This can be a very, very lengthy process. The case with Dalton Prejean, that case was almost 14 years long before the sentence was fined. Other responsibility of the DA's office: juvenile protection, crimes against the elderly, extradition, probation hearings, and law enforcement accountability. I touch on this because I know there's maybe some questions, but under the rules of ethics, there are special rules for prosecutors, and probably the most important one is right here, that we must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. In other words, we really can't talk about these cases while it is pending, because we can't prejudice the defendant in any way. So a lot of times when you hear that the DA won't comment on something, this is why we're prohibited for. Funding of the district attorney's office, that is a whole area. We could spend an hour on it. This is going to be an issue coming up. It's a current issue as well. The current issues, we need more court time for the prosecution of cases. We need additional court time with additional judges, as well as additional prosecutors. Gun violence is a big issue that we're facing. You've got drug abuse, substance abuse, mental health. We need to get early intervention with the community and law enforcement. And then the funding issues are going to be a major issue coming up. Current issues post-COVID, as was mentioned right now, bondsmen are not happy because basically you can commit a crime, you get issued a warrant, and you leave. It's catch and release, which means the sheriff at some point is going to have to pick all these individuals up. That's going to cause delays in the trials. The system's already overloaded. The loss of fines and court costs for pleas is causing funding issues. The IDO office has funding issues. We went through a period of almost 9 months where we couldn't have any trials because public defenders didn't have any money and they weren't coming to court. In our community, we've got a double whammy because of the oil and gas prices. My guiding principles in most of the prosecutors in our office is do what is right Public safety is a priority. Maintain honesty and integrity. Look for smarter and more efficient ways. And try to create paths and guidance for people to learn from their mistakes. Most people don't have involvement with the DA's office unless they're either a victim of a crime or themselves or their family has committed a crime. This was given to me by a prosecutor in Denver when I went to a conference on leadership there. And I think it sums up what makes a good prosecutor. It's an individual who seeks truth and not victims, an individual who serves the law and not factional purposes, an individual who approaches his task with humility, and a good prosecutor is someone who tempers zeal with human kindness. So that's kind of the overview of the district attorney's office post-arrest, and we're going to be open for questions very shortly. So thank you.
Thank you, Dan, and all of you who have gathered here today to learn a little bit more about the prosecution's office. In Berger versus United States, the Supreme Court proclaimed that a prosecutor is a servant of the law, the twofold aim of which is that guilt shall not escape and innocence shall not suffer. To protecting the community through the fair and ethical pursuit of justice and the safeguarding of crime victims' rights is part of the mission of the 15 Judicial District Office. Here we have two well-qualified candidates, both who have served in prosecutorial roles and are now open to your questions regarding their plans and proposals for the office, as well as any that pertain to the message that they've already shared with you in terms of criminal procedure. So we will proceed, as I will first take questions from the room, since our attorneys have come and taken extra time to be here at the Lafayette Bar Association Foundation office, while accepting questions online from our technical advisor. Anyone want to begin? Yes, and I'll repeat the question.
Okay, no problem. In Ramos, for unanimous juries, it is 12 to 12 on both sides, or 6 to 6 on both sides. Like we need 12 out of 12 for an acquittal and 12 out of 12 for conviction, correct?
Correct.
Our question deals with Ramos. Would you like to go and repeat it?
Yes, the question is on a conviction or not guilty. It's a question of whether or not you have to have a unanimous vote for the defense and the prosecution, correct?
Correct.
And the answer is yes.
Well, that was easy.
That's a legal question.
Anyone else want to continue on any of the presentation? If not, then I have several prepared, as a matter of fact. My students at UL Lafayette are particularly concerned with the relationship in the community between law enforcement, particularly the officers on the street, and minority members of the community. We're well aware that the district attorney cannot comment on any pending litigation or prospective litigation. But the question that I come from my students to you with is, what do you think of the relationship between our police officers, our law enforcement community, and the minority members here in Lafayette Parish, and if you would like, also Acadia and Vermilion Parishes as well. Don, I guess it would be your chance to speak.
I think that 99.9% of our police officers and our citizens get along just fine. I really do. I certainly recognize the fact that people can protest, peacefully protest, but I can tell you that my experience in 34 years was that the law enforcement officials that I worked with were always very, very dedicated to their job. They strapped on the holster, they put on the badge, and they showed up for work every morning to protect all of our citizens. And I understand, and I've seen mostly in the national news, that some officers are not doing that. But by and large, in our three parishes, I believe that we have a good relationship and we have respect between the police officers in our community. And I think that we certainly have a lot of things we can work on, but I really believe that overall it is good.
Yeah.
I would agree that we have some of the best police officers in the 3 parishes. In Lafayette, they're probably some of the best trained. We are just recently got $1 million in funding for additional training, which is going to be really good to help our community. There was a push for community policing, which was being very successful, and I hope that it comes back around. I intend, when elected DA, to have more community involvement and interactions between the district attorney's office, the law enforcement agencies, and the community leaders, because that is really important. Acadiana is kind of special. We're not going to be a Portland or a Seattle here. Overall, we all get along pretty well, and I think it will be fine.
Do you feel like there should be any federal training of our local police officers?
Actually, we are trained. The federal agencies are involved. I serve on a task force, which is Project Safe Neighborhoods, where we target neighborhoods and try to put resources into those neighborhoods. So there is federal involvement in most of these cases that police are involved in.
Okay. The next question I have here, again from one of my students, what do you consider to be your major accomplishments as you were assistant prosecutor in your respective offices? I guess we'll turn it over to Don to discuss his major accomplishments.
I think during my 34 years of experience at the DA's office, I'm proud to say that I was allowed to help a lot of people. It wasn't just about prosecuting serious felony cases, misdemeanor cases. It wasn't just about that. There are some areas where you can work with people and you can try to help them solve some problems and get them to the right place in their life without actually prosecuting them on every single crime that might come before you. There are those instances where you can look at it and it's maybe not black or white, there's some gray area there. And it is very rewarding to me when I'm out in the public and somebody might approach me and say, I don't know if you remember this, but 26 years ago, you helped me with this. And I really want to thank you for it. I've gotten a master's degree. I'm doing fine. I want you to know that you made the right call. So my 34 years of experience were guided by Nathan Stansberry also, who is a fine prosecutor, and then Mike Carson, who is also a good prosecutor. And both of those gentlemen allowed me to help people. It was their office. We always consulted with them, but they allowed us to help people. And they also gave us a lot of guidance when it was time to prosecute a case. We prosecuted a lot of serious cases, and I was very appreciative of their guidance and their knowledge. So that's what I remember most about the DA's office when I sit back sometimes and say, those 34 years were just great.
Thank you. Dan?
Well, I would have to say, in the last 4 years, one thing that has been, I'm really proud of is we have implemented a new case management system. We are in the process of reforming the office on how this case management system will provide service to the public. It allowed us during this pandemic to take 100 employees and go completely virtual. And as I tell people, during the pandemic, the Constitution does not go away. So we were able to protect the rights of the victims as well as the defendants and continue to have hearings. As a pretrial director, another thing I'm very, very proud of is we started a program and we're doing a test module in Acadia Parish for a juvenile pretrial program. It has been very, very successful, and we intend on expanding that into Lafayette and Vermilion Parish. You know, cases, 36 years, I've had a lot of cases and have made a lot of difference in people's lives. Probably one of the most memorable ones is the recent Shunick matter. To be able to bring Mickey home to her parents, that gave me such gratification. The prosecution team we had, if you had to have a casebook study of how to properly investigate and prosecute a case, that was the case.
It's significant to colleagues of mine and former students who knew Mickey Shunick. Any questions from the room, the attorneys here today? I have a couple more that we have here. Oh, we have one in the back, please.
I'm hoping this kind of segues into what you've already talked about. My question is, in terms of your office, should you be elected district attorney, what steps would you take to make sure that your assistants, in terms of their decisions on whether or not to accept a case, their decisions on whether or not someone goes into pretrial diversion, and the decisions on sentencing are applied equally under the law, regardless of socioeconomic status. Sorry, this is hot. And regardless of race.
Who wants to go first?
I'm fine.
Okay, Dan, repeat the question.
Okay. Basically, I'm assuming the question deals with how can we be consistent in our application to defendants in our system, regardless of socioeconomic, racial, any of those things, so that there's fairness across the board. I can tell you one thing that we started doing is that we have monthly meetings with the assistants. We discuss the cases. I have assistants come into my office all the time discussing cases with us. A lot of that also involves the police expectations. Obviously, in some crimes, there's set sentences that have to be imposed, but in the discretionary ones, I can say I'm very proud of the people that work in our office. They all have common sense, and I'm a big common sense person. I think that that's probably the biggest asset. I think we should probably have some consistency in all three parishes, not just Lafayette, Vermilion and Acadia. They need to be in all three parishes. So it's a learning thing. One thing that I want to try to do is to grab young people before they even get into the criminal justice system. I think a thing that has not been done with the DA's office, and there is a lot of criminal justice reform, I think prevention should be a major component of the district attorney's office. And I intend to initiate programs in that area so that we can divert people from the criminal justice program, because we don't need them in there. We need to have productive citizens.
Two words come to mind for me, leadership and supervision. I think that we need to meet with our assistants from day one. When I take office, we will have a big meeting in all three parishes, and we will sit down and we will discuss just what you brought up and a lot of other issues. Need some leadership and some supervision. We can't just concentrate on one parish, all three parishes. Since March of 2019, I've been traveling throughout three parishes, Acadia, Vermilion, and Lafayette. And I've talked to a lot of elected officials. I've talked to a lot of ministers, priests, citizens, and those two parishes, for whatever reason, don't feel like they're getting enough attention. And I believe that with the proper supervision and with some leadership, we can bring forth some programs to those parishes also to make sure that everybody is treated fairly. I've always prided myself in being a fair man. In my 34 years of experience, I prosecuted a lot of people. And some of those people that I prosecuted have come forward and said, well, all I can tell you, Mr. Landry, is you were fair to me. I deserve what I got, and I appreciated the way you treated me. I can tell you that my background is such that I treat everyone fairly. Everybody will be equal. It doesn't matter what income you have, doesn't matter what your race might be. Everyone will be treated the same. And we'll make sure that our assistant DAs know that they have to do it that way, with meetings and meetings and meetings. And we'll be there to guide them. We'll be there to tell them just exactly how we want things done. Leadership, I think, is important. Supervision is important. Thank you.
Okay. Let me give you a question from myself here. I wrote, what do you propose to do for people who are arrested and cannot afford bail? And I would like to direct this to Don, but let me remind him that the lavalier probably will work best if it's held down below Jim, not in front of your mouth. Go ahead. This is, what do you propose to do for people who are arrested and cannot afford bail?
Well, we'll look at every avenue to see if they may qualify. For instance, I mentioned at the very beginning of my discussion about a recognizance bond. If they happen to qualify for that, we'll look at their record. We'll look at the facts. We'll look at the circumstances. The fact that they can't afford bail is not the only consideration that will be given. We have to look at all of the other considerations too. The seriousness of the crime, of course. And of course, we want to make sure that they appear in court, that they're there for all stages of the prosecution and make all court appearances. That's what we're after. We'll use common sense. We look at all the facts, we look at all the circumstances, we look at the rap sheet, we look at everything, but that's only one of the many factors. The fact that they can't afford bail is certainly taken into consideration. And I know there's some criminal justice reform headed in that direction, but we have to consider the fact that we have to keep our community safe and the persons who might be victims of a crime safe also. And very important, the seriousness of the crime that is charged.
Danny, would you want to?
To me, it's important that we don't look at an economic situation concerning bonds. In other words, if you have money, you shouldn't be able to get bonded out, and if you don't have money, you shouldn't get. In other words, we need to look at the facts. We need to look at the rap sheet. We need to look at the crime. The first obligation of the district attorney's office is to protect the public. So that's the first thing we need to look at. Economic considerations should not come into play if it does not allow you to protect the public. We have, for example, our pretrial programs. Sometimes we have individuals that come into those programs that can't afford to be in the programs, but we provide scholarships to them so that they participate as the same as somebody that has money to participate in the program. Bonding would be the same situation. It shouldn't be a money-making thing. The main reason that you have bonds is to assure the appearance of the individual. You might be able to assess them and give them the chance. If it's not a real serious crime, let them out. If it's a marijuana charge or something like that. And then if they don't show up, shame on them. They will go to jail and there will be a bond set. We've got to move people out of the jail systems. That is something that needs to be done.
I think it was interesting you mentioned that I'm sure some of my students were not aware of who are watching online. We actually have made arrests in the COVID age and told people you're not going to go to jail until we solve this pandemic. And we expect you to be available for incarceration later. Is that the plan?
Basically, they will be served with a warrant. And at that point, there will be a bond set. And then if they make the bond, they don't go to jail. So if you think about it, it's kind of silly. They're out there wandering around, but there's no bond on them or a warrant on them.
And if they commit a violent crime, does that change?
No, that changes it because they will book them into jail. There's certain things that the sheriff's office will allow individuals to be booked, for example, domestic violence.
I just want to make clear that that wasn't left up to the district attorney's office. That's a decision the sheriff.
Oh no, that's absolutely not the DA's office. We're really not involved at that stage. So,
what do you propose to do about prison overcrowding?
well, the question is if you get them young enough and you defer them, then we're not going to have as many people. You know, we incarcerate more people in the entire country, and basically we're training them to be better criminals. So you need to take a look at the situation and see if in fact, by reducing the prison populations, you still have to go to public safety. Can you allow people out of prison? What are you accomplishing? There needs to be consistency, as she had indicated. Everybody should be consistently treated, but it's a work in progress because of all the stakeholders.
I can tell you on a local level, Acadia, Vermilion, and Lafayette, one of my big plans is to start prosecuting the serious felony murder cases. That will eliminate a lot of the population in our jails in Acadia, Vermilion, and Lafayette Parish. If we can move the big cases, the murder cases, for instance, in Acadia Parish, I believe there are 40 pending murder cases. only one trial in the last six years is what I'm told by the sheriff there. And he's bending my ear every time I go. You need to move those cases. You need to try those cases. Get them out of my jail, send them to Angola or one of the other state prisons. Then I get to stop paying for their medical bills, their diabetes medication, and all the other things. So that is something that is one of my goals, to prosecute the serious felony cases and clear up some space for our sheriffs in Acadia, Lafayette, and Vermilion Parishes.
Lenny, do you want to speak to that issue? 40 cases seems like a lot.
Well, I think that information is inaccurate. So I know we've tried over 120 cases in the last 4 years, but the question, it comes back to funding and time. You got to look at the systemic problems in the system. We need criminal judges handling criminal matters. A lot of people don't understand that the judges that get elected, and we have several candidates here, they handle both civil and criminal. We're only allotted so many weeks a year. Unlike Orleans Parish, where they have a dedicated criminal division, you can't get the cases moved. About 8 or 9 years ago, we convinced several judges to give us what was called a super docket, where we were allowed to clear out the backlog. But it's just been one thing after the other. You started with the restriction of services with the Public Defender's Office. You then came in on a limited amount of time that we had to try the cases. Then you throw in COVID on top of that, and you throw in the Ramos, and you have a perfect storm. And then underneath all that, let's cut the funding so that we don't have properly funded system to move these people out of jail into trial.
What would be the kind of funding reform we need to try to resource this office? Obviously.
Well, it's a reallocation of income and expenses. I mean, for example, in Lafayette, the 15th, we have 19 warrants. Okay, and to explain it to people that are listening, a warrant is an amount of money that the state gives the district attorney for supplementing and payment of the district assistant DA's salaries. We only have 19 warrants. We should have 34. So I intend on going to the legislature, and of course it's economic and funding issues, to raise those funds to come into our parishes so that we can do that in all 3 parishes.
Ron, do you want to speak to the funding question?
Yes, I just would not have waited that long to go to the legislature. In the last 6 years, I'd have been there begging. I'd been on my knees asking for more money. I think that with some cooperation with local officials, with our legislature, we can get that money. And I don't mind going to New Orleans or wherever I have to go to ask for more judges and more court time and have some judges sent over to help us. And I understand that cases have been tried by the district attorney's office. That's not the example I gave. The example I gave was 40 pending murder cases. That stat was given to me by the sheriff in Acadia Parish. Only one was tried. I think that we can move more cases than that, even with the limited funding, and clear up some space in our jails. And that's what I promised the sheriff that I would do. I will work real hard to get my assistant DAs to do just that.
What do you think is the most effective way to deal with low-level drug offenders? Low-level. I noticed the arrest reports that were given for marijuana possession. What's the most effective way to deal with that?
Well, I think they're dealing with them now with the COVID-19. Those people are not having to post any bonds, and even before that, those types of cases, the bonds were not very high. And in most cases, when I was at the DA's office, we could get with the defense attorney, look at those kinds of cases, look at the rap sheets and look at those kinds of things. And in a lot of those cases, that ROR bond was appropriate and could be used to let those people out of jail. And we did just that. We met with the defense attorneys before the bond reduction hearing. We went through the files, we looked at the rap sheets, we looked at all the circumstances. We, of course, considered whether or not we would be protecting our community. And with that type of an offense, we must follow the law, of course. We have to follow the rules. But I think that would be an appropriate case for an ROR bond.
Well, first question that I have is, we're using marijuana as an example. You don't have drug dealers if you don't have users. So if you take the users away, you may get rid of the drug dealers and the violence and the guns and all of that. So when you arrest somebody for marijuana, one of the things that we do through our pretrial programs, we do assessments. We determine if this person is a recreational user, whether it's an addict, what's involved in it, so that we can make a decision at that time. They may just need educational resources to nip a addiction in the bud at an early stage, or they may be hardcore addicts that need something different. So that's back to that prevention that I'm talking about, and the intervention with the younger people, so that we don't have to worry about people like that would be taking up jail.
Question.
Yes, sir. And I know both of the panelists will probably know what the question I'm going to ask is going to be, but there has been for years a no-drop policy on domestic violence, domestic abuse cases, and quite a few of victims end up showing up in court and saying, I don't want to go forward. I thought this was just a mistake. It was a one-time thing. There's a balance between no drop, we prosecute every single domestic violence case, and maybe this case needs to be looked at more closely. Is there a way to balance those two needs? Because we don't want victims being pressured into dropping cases. At the same time, we don't want it across the board. We have to prosecute every single domestic violence case, regardless of what the victim's intent is. So do either of them have any thoughts about how we balance those two needs?
And I must ask you, I know it's a very important and involved question, but please try to.
I'll be happy to answer that, Richard. If you realize, recently we had a tragic situation here in Lafayette where a mother was murdered by her husband. In that case, she wanted those charges dropped several times, and the prosecutor, declined to do that. So at some point, it has to be a judgment call of the prosecutor. We have an obligation to be sure that the victim is protected, and we try to send them into counseling to get help. So when you say there's a complete no-drop policy, that's not actually accurate, because many times we will bring in the victims that want to drop the case, and we will sit down with them away from their husband or their significant other, and have them speak to somebody from the faith house or somewhere to be sure that they understand what they're doing, so that we don't get that phone call from the detective at 2 o'clock in the morning that they've been murdered. So it is not a strict hard line, we don't drop it, but that's a unique situation dealing with domestic violence.
No?
I agree. That's something very difficult that we have to face. I think all of the attorneys here in the room will acknowledge that. It would be my intention, and I have received a lot of information on the campaign trail. A lot of people have offered to volunteer who are psychologists and who have talked to me about that very subject. And the suggestion has been made that they would volunteer and without any payment, work with our office on a limited basis and help us to talk to victims of domestic violence. So I think the approach would be to talk to them and talk to them a lot and bring in a professional with you before you even consider dropping the charge, because sometimes we have to have the victims, sometimes they don't want to protect themselves. After a certain point in time, they decide, well, maybe it wasn't so bad and maybe dad needs to come home. We know of those kinds of instances. Danny just named one where this lady tragically lost her life with children at home. So it's not an easy, Richard, it's not an easy thing to answer. And I would hope that once elected, you would agree to serve with us on some type of a little committee where we can talk to these psychologists and see if we can develop a good plan to address that very issue. Because I understand your point, the point that you're making, I understand it very well. We want to make the right decision, but we can't make it like it.
Speaking of mental health, it's clear from my conversations with police officers They do not like being put in the position of a social psychologist when they have a person who's having a psychotic break. We saw tragically what happened in one incident when a naked man was obviously out of his mind and raving and lost his life in the midst of apprehension. Of course, we lament anytime that happens. But here's the point. Mental illness has become a job of the police officers now more and more, and it's sent people who have schizophrenia, bipolar disorder to jails with the same population of hardened criminals. Certainly there has to be some reform, and what must it be to take the police out of the mental health business and put the psychiatrist and the mental health industry back in?
Totally agree. The problem, once again, is that nasty word funding, because what happens is the mentally ill individuals are incarcerated, they're medicated, they calm down, they get released, they don't take their medication. Next thing you know, they show up at a car dealership and stab 3 people, or show up at a mental health facility and kill one of the doctors.
But most of them are not violent. We want to be very cautious about that.
Right, no, and I'm talking about the violent ones, the bipolar, schizophrenic type situations that have resulted in them being arrested because of physical attacks on individuals or police officers. I'm not talking about the homeless individuals that get arrested for vagrancy or something because they're unable to take care of themselves. There used to be on staff people in the jails to try to send them to facilities and help, but those facilities aren't available anymore. So, one thing that we can do from the prosecutor standpoint is, for example, this new case management system. We have modules that will indicate if somebody has a mental health problem so that we can appropriately define a sentence that would try to get them the help. The law enforcement agencies also will indicate to us if there's a mental health issue. So the more information we have about what's going on with them, the better we can serve them. But we go back to that nasty word, funding. We've got to be able to have the facilities and the help and the psychiatrists. I actually spoke with somebody from the Department of Health because I'm trying to get a psychologist, a psychiatrist to be able to work with our pretrial program with the young people that we started in Acadia Parish to see if we can identify people with potential mental health issues so that we can direct them to the proper resources.
Unfortunately, it's not just a local problem, it's not a state problem. It's a national problem. And it dates back many years ago when we gave people with mental health problems, we gave them their rights back, right? They're not committed to institutions the way they used to be. They're not medicated the way they used to be. But Danny made an excellent point. You can bring them under control, they take their medication, but you need some help, you need some assistance to make sure they continue with their medication. And so that we have to develop some programs. We have to get the help of our communities, of our ministers, of our priests. It's a community problem. It's not just a police problem. You can certainly understand why the police make the statements they make about that. They are not mental health professionals. They're there to do a job, protect public safety, but they do receive training, and perhaps we could even offer some more training, but that's not where we can solve the problem. We have to start on a national level. We've got to bring this under control. We see it almost every night on the evening news.
I have a question here that actually comes from my wife. She thinks that we're getting more violent in the Acadia region in our parish. She's noticing more shootings, more attacks. You gentlemen have been in prosecution for 30 plus years. Is that the case? Are we becoming a more violent vicinity in terms of the 15th Judicial District?
I would say that 2 things. One is that the news media and with social media particularly, you're seeing more about it, and social media is desensitizing the young people to violence so that they don't think anything about the violence. We are seeing some increase in violence. It's not as high. If you statistically look at it, it's not as bad as everybody thinks. But the statistic that's frightening is that most of the violence is between 17-year-olds and 25. And that's the scary part, because that means they've been dehumanized. They don't think anything about pulling a trigger. In the old days when Donald and I were growing up, if you had a disagreement with somebody, you'd get in a fist fight and then it was over with and you'd go play baseball or something. Now they shoot each other. And I fault a lot of that on the dehumanizing aspects of social media, and I'm seeing that happening. But the frightening statistic is that it's getting younger and younger.
I see.
I think the answer to your wife is yes and yes. I think we are seeing a lot more violence, and I agree with some of the things Danny said, but if you talk to the people in Vermilion Parish and Acadia Parish especially, there's a lot of gang violence. And there are some young people involved, but it runs the whole spectrum of age. There's a lot of violence in those two parishes from gangs, and that needs to be brought under control. And I'm getting that from the law enforcement officials. And certainly we want to do everything we can to give some proper guidance to our youth. We can do that, but what are we going to do about the games that they see on television, the games that they play? They see all of this and they think nothing of pulling a trigger because they are desensitized to it. I would say that we have to work on that problem, but we have to work on it not only on our local issue, but also on the national level. And quite frankly, I'm not sure what the actual answer is, but certainly we can't give it up. We can't give up. We have to keep working at that problem. We have to try to return some respect to our communities, respect to our law enforcement, respect to each other. I think that we see a lack of respect out there, and I think that's kind of where it starts. And then they go on to the bigger things. And we see them pulling triggers when you wouldn't think they'd be pulling triggers.
I see now that we've achieved the top of the hour, and I believe we've covered a lot of territory. We don't want to exhaust either the lawyers here in the room or my students. So I will invite you to make any closing comments before we adjourn for our meeting today. Dan, you want to go first and talk to people just before 40 days now from the election? So,
yes, and Professor, thank you for moderating this, and thanks to the Lafayette Bar Association for having this function. I've served this community for 36 years as a felony prosecutor. I started 2 years out of law school as a felony prosecutor, and I've seen the worst in human beings, and I've seen the best in human beings. I had the pleasure of serving with Nathan Stansberry, served with Mike Carson and Keith Stutz. I've learned what works and I've learned what doesn't work. We are in a major situation in our country with the rule of law, and I am qualified to take the district attorney's office, this community, to be proactive with criminal justice reform and to make a difference and continue serving you as your public servant. So I would just ask on November 3rd to please remember to vote Danny for DA. And if I'm always available, call me. I'll be happy to speak with you. I'm always open to new ideas. And so please give me a call. And thanks again for y'all's attention and participation today.
I also join in thanking you for moderating. Thank you to the staff here. It was a pleasure to be here. It's a pleasure to talk to all of you. Donald Don Landry, number 81 on November the 3rd. I have been a resident of Lafayette Parish for a lot of years, but I started off in Broussard, Louisiana. I'm a small town boy, and I learned a lot of things through my life experiences. And I want you to all know that I was a paper boy, I mowed yards, I picked up garbage, I waited on tables, I sold furniture, I sold sporting goods stores, and I was very fortunate to be able to attend UL, and I was very fortunate to attend law school. I've had some great breaks in life, and I really appreciate it. I'd like to put my 34 years of experience, 14 with Nathan Sainsbury, 20 with Mike Carson, to work for you. And I can promise you this, I will be the accessible candidate. I have my phone number all over the place. When I get a phone call, I return the phone call. My constituents will always receive a phone call. They will receive it from me, and they'll certainly receive it from my assistants. I will work with the local officials. I will work with law enforcement. I will work with the constituents and let them give me their ideas also. We don't know it all, but by meeting with the local officials, by meeting with our constituents, by meeting with the businessmen, they know their problems. And please, help me fight this terrible drug problem that we have. We didn't mention much about it, but in the last month, I've had to go to 2 funerals. Good friends of mine whose children were affected by drugs. We're going to work with those local officials. We're going to work across parish lines, and we're going to get the drug dealers. With the cooperation of all 3 sheriffs and myself, we're going to be able to make a dent in this drug problem. I don't want to get a phone call telling me about the fact that somebody's child is in jail and they're actually happy about it. What do I mean by that? They're happy because the child is safe for a few days because he's in jail. I don't want to get those kinds of phone calls. We have to address that problem. It's a serious problem. And we must move some of these serious felony cases, and I'm specifically speaking about murder cases. We have to move them. We have to get them out of jail, give some closure to our victims and to their families. They expect it and they deserve it. Again, number 81, November 3rd, Donald Don Landry. Thank you very much.
Thank you to both of our candidates. Thank you to those who are watching online and to those who are here today. The Pew Center says only 55% of the registered voters decide in a presidential election. Even more alarming, digital new millennials do not have full faith in the democratic system. We must make it our resolution to encourage them to support democracy, to participate in their civic duty and vote for one of these candidates and haul up the ballot 40 days from today on November 3rd. Thank you again, and good night.